Good morning. Are you Roderick Randall? And Mr. Rojas, will your client waive the formal reading of the motion? Mr. Randall, in clause number 24, DCCR 0543, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 7th of 2024 for the offense of aggravated robbery, a first-degree felony, and you were placed on a 5-year deferred probation. Is that correct? Speak up. This motion alleges that you violated your probation. Count 1 alleges that you were arrested for the offense of unlawfully carrying a weapon on May 3rd of 2025. And is that true or not true?
True.
Count 2 alleges that you were arrested for the offense of evading arrest or detention May 3rd of 2025. And is that true or not true? Count 3 alleges that you possessed a drug, marijuana, May 3rd of 2025. And is that true or not true? Count 4 alleges that you failed to provide verification of completing community service hours. Is that true or not true? Count 5 alleges that you did not provide verification of entering and successfully completing the anger management program. And is that true or not true?
Judge, count 6 is duplicative of their accounts.
Okay, state abandoned 6. Count 7 alleges that you failed to provide verification of attending a drug and alcohol awareness course. Is that true or not true? Count 8 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you provided a urine sample April 2nd of 2025 that tested positive for marijuana. And is that true or not true? And then count 9 alleges that you're behind in your court-assessed fees. And is that true or not true? Did you enter your pleas of true to counts 1, 2, 4, 5, 7, 8, and 9 freely and voluntarily? And did you plead true to those counts because they're actually true? And so I have some documents here on the computer that have your signature on them that shows that it looks like you've made an agreement for me to continue.
Hold on for a second. Did you catch how serious that moment was? This defendant is already on deferred probation for aggravated robbery, and now the court is hearing allegations involving a weapon, evading arrest, and drugs. Judge Raquel West is basically saying you are standing inches away from losing your freedom for decades, and yet she is still considering giving him one more shot. That is the balancing act in probation court, punishment versus rehabilitation.
Your probation and send you to ISF cognitive track. Is that your understanding?
Judge, I realize it's troubling that he's committing misdemeanors and has a gun on him when he's on probation for aggravated robbery. I also know that the court could sentence him up to life for 99 for violating his probation. So this, to me, appears to be a one opportunity for him to get his life right before he's locked up for most of it.
So here's what I want to do. I want to get an updated report. I want a little more information about that new offense, PC and some things like that. And then I'll decide if I'm going to go along with this when we come back at sentencing. So I am going to reset the case for sentencing. I want to get more information about those new offenses and what's been going on, and then I'll determine whether or not I'll follow that agreement. It appears, at least for now, that you don't have any substantial. Is there any?
There's
anything?
One very minor
Okay.
write-up that was provided today for horseplay.
Okay. So it's very important.
Notice the warning hidden inside the judge's calm tone. She says she does not want to see a stack of incident reports when he comes back. That is courtroom language for, do not mess this up again. Judges pay attention to everything between hearings: police contact, new complaints, failed tests, even small violations. One bad report before sentencing can completely destroy a plea agreement. Right now, the defendant is walking a razor-thin line between rehabilitation and a life-changing prison sentence.
That I don't have a stack of incident reports in front of me when you come back. It looks like you've been doing well. It is very important that you continue to do that because that could influence me one way or the other as well. Okay? All right, and go back with the bailiff. please in the motion, and then what about the new case?
The case is clearly not true. There's an administrative thing. I think the victim did a lot of prosecution. Or is it
Computers.
It's not the case.
Ms. Mulfeely.
I can't speak to what she.
I'm sorry, my screen is still loading. Is everybody's spinning?
I don't see a motion for the bond. We'd ask for 3 days. I'm not.
should have requested one in the letter, not the motion itself, or the notice letter.
Request for probation bond and speedy hearing
Revocation hearing.
was filed August 18th. Let me just go through this motion first.
It's the same one always.
Mr. You're Nathan Lamel. Mr. Lamel, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. Will he waive the formal reading of the motion?
So
All right, Mr. Lamel, in cause number 24, DCCR 0826, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation February 17th of 2025 for the offense of evading arrest or detention with the use of a vehicle, third-degree felony, and that was a 5-year deferred probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you were arrested for the offense of burglary of a habitation, April 26th of 2025. And is that true or not true? You weren't arrested?
well, he was arrested.
That's what the allegation is. And I'm not, anyway, y'all, I don't know why they've changed.
Okay? This is where things suddenly get very technical and honestly, very important. Judge West is pointing out that the motion says the defendant was arrested for a crime instead of alleging he actually committed the offense. That may sound minor, but legally that wording matters a lot. An arrest alone does not automatically prove wrongdoing. The judge is basically warning the prosecution that sloppy paperwork can become a serious problem in court. And this right here is why precise legal language can completely change the direction of a case.
Them to just arrested, because being arrested isn't really a violation instead of committing the offense. All of a sudden, all these motions are different. Y'all might want to take a look at that. They're not alleging that they committed the offense.
I apologize. He was arrested, so that would be true, but I don't think it's a violation.
All right, so count 1, you're pleading true to? Okay.
You were arrested.
Count 2 alleges that you failed to avoid injurious or vicious habits as directed. I don't know what count 2 is either. No, just don't worry about it because it doesn't say what it was, and so I don't think that is an accurate. I don't think I can go forward on count 2. Count 3 alleges that you failed to report to the probation office March 5th and April 9th of 2025, and is that true or not true? Count 3 is true. Count 4.
Just to be clear, I think what he said was it's true that he called in. So I don't know.
Did you report or did you not report on March 5th or April 9th?
I think what he said was he didn't report, but you called him.
I don't need to know that. I need to know if you reported as directed on March 5th and April 9th of 2025.
Hopefully not true.
Count 4 alleges that you provided a urine sample May 1st of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true? It's marijuana, THC. Did you test positive on May 1st? Speak up. Okay.
Not true.
Count 5 alleges that you were at a location other than your residence at 3:01 a.m. on April 26th of 2025. And is that true or not true? Count 6 alleges that you tested positive on May 1st of 2025 for alcohol. And is that true or not true?
Not true.
Did you enter your pleas of true to counts 1 and 5 freely and voluntarily? And because those 2 counts are actually true. All right, then I'm going.
Wow, you can actually see the confusion unfolding in real time. The judge thought the defendant pled true to being out at 3:00 in the morning, but defense counsel immediately jumped in to correct the record. This is exactly why hearings move slowly and why every single word matters. One misunderstanding in court can accidentally turn into an admission of guilt. And honestly, this moment shows how quickly probation hearings can spiral if attorneys are not paying close attention.
Find that you entered your pleas of true to counts 1 and 5 freely and voluntarily. Find those counts true. Find sufficient evidence.
I think you pled not true.
1 and 5?
That's my understanding.
He pled including.
No, 5 is 3:01 a.m. I thought he said.
Not true.
I wrote that.
Oh, I'm sorry.
He's
So,
only played 2 to number 1.
Right.
okay, so you're saying that it is not true that you were at a location other than your residence at 3:00 in the morning on April 26th?
When you were arrested, that was your residence or wasn't your residence?
It wasn't mine.
You said it was his residence, that he was
That's what I was
arrested, that's what you were saying. So it's not true.
Okay, count 1 then. All right. So I'm going to reset your case for a sentencing hearing. Obviously, the state can bring any evidence with regard to the allegations that you pled not true to. Also, y'all might want to make a note, go through if there's going to be any amended motions. Looks like I've seen several like this that need to be addressed.
It doesn't appear that the offense is alleged, Your Honor,
It's not at this point, correct?
but there's a non-prosecution itself.
That's all right. So we'll get an updated pre-sentence report in this case. And so Mr. Kimler filed a request asking that I set a bond in this case. Give me just a second before I get into that to go. I'm going to take a look, for the record, I'm going to take a look at the probable cause affidavit in cause number 25 DCCR 0744, which is that new case. So give me just a minute. Yes, ma'am, it's unagreed. Printed it. It's easier for me to read in person. Mr. Kimler, do you have any evidence with regard to that bond?
His ability to post the bond, Your Honor, is that what you mean?
Do you have any evidence with regard to your request for a bond?
Well, just that he's on, I believe he's on deferred. What's your financial basis? I think you employed or you lose your job because of your arrest.
I had a job that I was
Where were you working?
I had just started.
I can't, if I, don't make me tell you to speak up again.
Now the tension shifts from probation violations to bond arguments, and the judge is clearly not convinced this is just a harmless domestic dispute. Listen carefully to what is being described. Alleged trespassing, returning after being warned away, aggressive behavior, and a broken window. Even when an alleged victim says they do not want to prosecute, judges can still look at the surrounding facts and decide someone
I would just say he doesn't appear to be an absconder, just 2 days.
Well, my issue I mean, regardless, I guess at this point, until we have more information about whether or not the complaining witness is going to go forward, is that it appears as though
Domestic dispute, right?
well, he had already been trespassed, warned by the officer. I believe that same day, left with his mother, and then the allegation is he came back and then was aggressive with officers. And that the allegation is that there was a window that was broken and coming through a window, so that doesn't.
I think the victim, the alleged victim's present, Your Honor, if you want to.
I'd like to renew the state's position that we weren't prepared to avoid. In fact, on the bond today, in fact, there's no a copy of that letter that Mr. Kim references. You may have a copy there, but I don't have a copy filed. We asked for at least a couple of days to.
Did you just send that to us, or did you e-file it?
It was e-file, I don't know if she tagged. I mean, I don't do that.
You got to make sure they have notice of that. So at this point, what I'm going to do, hold on just a second.
She is present.
We're not prepared.
Yeah, but they haven't talked to her or prepared for anything.
I don't understand why they didn't get a copy of the list if it's filed.
Well, it was
It wasn't a motion.
a
Oh,
letter.
There's a motion filed.
We have neither a motion or in file.
Well, that's their problem, Your Honor. I mean, it's not mine. He's in jail.
And there it is. The courtroom frustration boiling over. Everybody is arguing about whether documents were properly filed, served, or emailed while the defendant sits in jail waiting. Judge West is basically saying, I do not care whose fault it is right now. I need the full picture before making a decision. This is the side of the justice system most people never see. Delays, procedural mistakes, missing notices, and technical disputes that can completely slow down a case. But what do you think? Should procedural errors ever affect somebody's freedom, or should courts focus only on the allegations themselves?
Well, if it was e-filed and sent to the correct people, then I don't know that it's necessarily their problem or an electronic problem or a problem that your office didn't send it to the right person. So we're not,
But it was e-filed. My point is it's on file. It's on file.
the state has to be aware of it. Just hang on a second. I see that he's in jail. It's a jail docket. I also have some concerns whether she's here or not with what was going on, because just because she says she doesn't want to prosecute doesn't mean that I think she's safe with him doing what this allegation is after he was trespass warned from going over there. Yeah, I guess when you do need to make sure, I have it from the 18th, the request for a reasonable probation bond and speedy probation hearing comes now, blah, 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 asking for it. An order was attached as well. So somewhere it got either lost or something wasn't done correctly one way or the other. Doesn't matter at this point. We're here. My bigger issue is probably the same issue that the state's going to have. I want them to have time to talk to her. If she's going to file something and it changes the status of this, then we'll deal with that at that time.
She has filed a non-prosecution.
You have that in the file?
Okay. And one final thing I'll say on this is, it's one thing to e-file something, but it's a whole other thing to make sure that you hit the tab or.
I've gotten there too. I've already said. I understand, and that's what I'm saying. If the right service wasn't sent, then it's an issue on your side that they didn't get it. Make sure it's done correctly.
I mean, you can see on the e-file notification
That it was sent to her. Okay, so it was sent. Is Miss Malfino upstairs? All right, let's get her down here real quick, please.
All right, let's go.